when we go on the record, I'm going to be asking you a bunch of questions.
Okay.
If you don't understand what I'm asking you, you need to tell me that so you and I can talk about it and make sure that we're on the same page, okay?
All right.
If at any time before you answer one of my questions, you want to talk
Judge,
to
I
me,
apologize. I'm having some technical issues.
all right, it's probably my email. I wish I could shut off my send receive during this because every time I get an email, I break up. Can you hear me all right, Nick? No.
I'm going to try to get off and get back on.
Okay. Yeah, because we could, well.
I can hear you just fine.
All right. So anyway, while Mr. Campbell's doing that, Mr. Hill, I ask you a question and you want to talk to Mr. Duma in private before you answer it. You just tell me that. I can do what we call it a breakout room. I send you guys to a private room and you can talk without any of us hearing you, okay?
Okay.
All right. We'll just wait for a prosecutor to figure out his computer here. You must be having, oh, here he is.
Judge, oh, there we go. Okay.
All right. You in the land of the living now?
Yes, I can hear now. Thanks.
Okay, good. All right. Then, all right. Then let's go ahead and be on the record in case number 2019-CR617, captioned State of Kansas versus Shaquille Hill. Would the parties announce their appearances, please?
May it please the court, State of Kansas appears by Assistant District Attorney Nicholas Campbell.
May it please the court, Mr. Hill with counsel Michael Duma.
All right. We are here to sit down to take up a plea hearing today. Mr. Hill, you and I got to talk a few minutes while we were waiting to get started about what we are going to do today. And to ask you all those questions I told you about, I need to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
All right.
Right.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right. Mr. Hill, go ahead and put your hand down. How far did you go in school, sir?
I completed high school diploma.
All right. You read and write okay?
Yes.
All right. As you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what you're doing today?
No.
Feel like your mind's clear?
Yes.
All right. Do you know what you're charged with in this case?
Yes.
All right. In fact, did we, gentlemen, was there a preliminary hearing held?
Yes, it was.
There was, Judge, yes.
Yeah,
Yes.
I think. Yeah,
Sorry,
I think,
I was not the original prosecutor at that time, but I did just check and there was a prelim.
I wasn't
And
there.
that
either,
was-
but I reviewed the transcript.
okay. That's while we were still doing them in the basement, correct?
Correct.
Okay. All right. So I guess getting back to what I was asking, do you understand what you're charged with in this case?
Yes.
You know, you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial in this case. You understand that?
Yes.
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Duma would help you throughout that trial. He would cross-examine and confront all of the state's witnesses, challenge their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power to make them come to court. At that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, they couldn't argue you must be guilty because you didn't tell your side. Do you understand all those rights?
Yes.
Right. And if we had that whole trial, and at the end of that trial, you were found guilty, you would have a right to appeal that conviction to the appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes.
All right. Now, if we go forward with this plea today, you're going to be giving up all of those rights. There's not going to be a trial of any kind in this case. You understand that?
Yes. That's understandable.
All right. So I'm going to share with you now what your attorney sent me as the plea petition in this case. I'm going to kind of quickly scroll through it here. Can you see that?
My bad. I'm gotta get up a little close, but I can see now.
Okay, good. Did Mr. Duma have an opportunity to go over this document with you?
We've spoken about the plea agreement, but not the document itself. So,
Okay. All right. So very quickly, I'll go over this with you. Basically, if you see, it talks about your name, whether your mind's clear today, whether you know what you're charged with, all of these things that I've kind of asked you today. That you have a right to plead not guilty, and all of those rights to trial and the things that go along with them, including the right to appeal. And then a statement that you understand that by pleading guilty, you're going to be giving up those rights and not going to trial. Then it goes down, it talks about the maximum punishments. You and I will talk about that here in a little bit. If you were under any other kind of sentence in a Kansas case, that this case would have to run consecutively to that. Nobody has promised, suggested, or predicted that you're going to get a lighter sentence or probation for pleading guilty. I don't think the deportation consequences you have to worry about. I think you're a U.S. citizen. There's the plea agreement. You and I will talk about that some more. And then the other ones are basically, I'm going to ask those questions at the end. If you understand everything that's going on, understand everything in this document and want to do this. Okay?
all right.
All right. So where I've kind of landed here is where it says what the plea agreement is. I'm going to read that to you. It says you're going to be pleading guilty to count 1. That's an aggravated robbery, a severity level 3-person felony, and also to count 4, which is a criminal threat, a severity level 9-person felony. The state's going to agree to recommend that I run these sentences concurrently. In other words, at the same time and not one after the other. That the state is not going to oppose your lawyer's motion to depart downward to a sentence of 30 months. No other party will be seeking a departure of any kind other than that. And that you agree to be responsible for full restitution jointly and severally with your co-defendants on all of the counts, even those that are getting dismissed. Is that your understanding of the entire plea agreement, Mr. Hill?
Yes.
Has anybody promised you anything else to get you to plead guilty today?
No.
Has anybody placed any force or threats against you to make you plead guilty today?
No.
Okay. So I see as part of this agreement, is everybody agreeing to recommend certain kind of sentences, okay? Concurrent sentences and departures to 30 month and all of that. Now you understand, I'm going to listen closely to what everybody recommends, but I'm not a party to any of these agreements, and I can give you any sentence that the law allows me to give you. You understand that?
Yes, I do understand.
Okay.
Can
Gentlemen, what do you believe that Mr. Hill's criminal history is going to come out to be?
Your Honor, I believe it's an H.
Judge, I have no reason to doubt that it is an H. Mr. Hill, I have talked with him and he reports that he does not have any prior felony convictions.
All right. So I'm sure, Mr. Hill, that Mr. Duma went over with you those sentencing guidelines and where you take the level of the crime and you match it up with the criminal history and you come up with a projected score. All right.
Yes.
I will tell you this. As I sit here right now, I don't take any position as to what your criminal history is. These lawyers are both very good. They look in and that this is their best idea. But I have to assume, just for today's purposes, that you have the very worst criminal history possible so that I can advise you of what the maximum that anybody can possibly get for these crimes are. You understand that?
Yes.
All right. So if you were in A criminal history, the very worst, you could get up to 254 months and a fine of $300,000. Mr. Duma, is that calculated with both the counts together as far as the months in prison?
It is, Judge. It's the maximum he could receive on both counts if they were run consecutive.
Okay,
And the second count being dropping him down to a criminal history category I.
correct. All right. But the fine is $300,000. That would reflect the maximum fine for count one. The maximum fine for count two, or the count four, would be $100,000.
That is correct, Judge, yes.
All right. And any of those would carry 36 months of post-release supervision. Do you understand, Mr. Hill, that those are the maximums that anybody can get for these crimes?
Yes, I understand.
Okay. Now, do you have any question for me about anything that we've gone over today?
No, I do want to ask my lawyer a question.
All right, let me let you do that in private. I'm going to set up a room here and you can step out to that. Hold on one second.
All right,
I
appreciate
got to
it.
stop the share to do that. All right. There they are, gentlemen, if you would accept. All right. I wish there was a way to pause the live stream so you didn't have to shut it down and start it anew so you all could be at your leisure, but there's no way to do that. So here we are. Here we go.
Judge, my client's question was whether or not this was a registerable offense. And I told him that's not something that we had contemplated as part of the plea agreement, and I don't, at this very moment, I don't know the answer.
Your Honor, it is a registrable offense. I believe I included that in the plea that I sent. However, it's by operation of law. The count one that he's pleading to was committed with a deadly weapon. It is a person felony, so it is a registrable offense.
Is that 15 years?
Yes.
Okay. Could I have another moment to talk with my client, Judge?
Okay. All right. So, Mr. Hill, I can confirm that the law states that if somebody is convicted of a person felony and it is proven that it was done with a deadly weapon, then that does require the defendant upon release to register as an offender for a period of 15 years. Okay?
That's in the state of Kansas, right?
Correct. But my understanding would be that you would have to register. I don't know how it works if a person required to register leaves the state of Kansas, are they required to register in that state or not? I would assume that they are, or at least they are to continue to register. I frankly don't know how that works. There's simply no way to think that it would be that if you leave the state, you don't have to register. Everybody would just leave the state to avoid it. So I know that that's Kansas law. I am certain that wherever you go, whether you have to register back here somewhere as a foreign registrant, or if the states have some sort of compact where you can register where you live, I am uncertain, but I am certain that they would make you require you to register throughout that period. Okay? All right. Mr. Campbell, did you have something to add? You look like you did.
No, Your Honor, I believe it is that if go to Missouri or a different state, that they would have to register there, but I believe that can be explained. But the biggest thing is obviously registering somewhere when they're
Correct.
required to.
And putting a defendant on notice that he'll have to do so. Yeah.
Yeah.
Okay. So, Mr. Hill, you had an opportunity to talk to Mr. Duma. I'll ask you again. Do you have any questions for me about anything we went over?
No. I believe Duma wanted to talk to me one more time. I'm sorry.
We could, Judge.
You want to go back out? Is that
Yeah, just very briefly.
okay? All right. Let me see. I got to do this. And I'm going to open it. No, that did not work. Maybe it did work. I don't know. There. You both should have gotten a new invite.
Got it.
All right. Well, I can only speculate that that might be a collateral consequence that the defendant has not considered in taking a plea or not.
In the plea I sent, I mentioned it was a registrable crime. So, but I understand sometimes people miss that stuff like that. So.
Sure.
Judge, did I tell you my son decided not to go on that trip with us because he doesn't want to risk getting stuck in Mexico if he doesn't get a negative COVID test?
Right. Yeah.
So it's just the girls now.
I assume that if you were unlucky enough where you got down there and you tested positive, you're going to be responsible for your own living expenses
I think so too.
until you're able to test negative and get home. Wow.
Yeah, what I'm going to look into now is the fact if we've been fully vaccinated, can we show that rather than testing or?
Right.
So I need to find that out.
I think I heard somebody discussing it. I'm not sure. If you're vaccinated, well, your antibody shouldn't cause you to test positive. So
And it'll be 12 days after the second injection that we leave. So
yeah,
any sort of flare up should be gone by then.
yeah, I would hope so.
We're all set, Judge.
All right, we're good to go?
Yeah.
Okay. As soon as he makes it back. Here we go. All right, we're back on the record. Mr. Hill, okay, I think Mr. Duma indicated to me that you're ready to go. Again, any questions left over for me or anything? And look, I don't want to sound exasperated because I'm absolutely not. I think it's a really good thing. And I think it shows that you're really paying attention to make sure that all of your questions are asked because this is a big decision you're making. So again, anything left over for me that you need to ask me, anything like that?
No questions.
Okay. Now, knowing everything that you know now, do you still want to go forward with this plea?
Yes.
All right. Mr. Duma, do you know any legal reason why your client should not plead guilty in this case?
No, Your Honor.
All right. Then I'm going to ask you, Mr. Hill, as to count one, that charging you with aggravated robbery, a severity level 3 person felony. How do you plead, guilty or not guilty?
I plead guilty.
All right. And as to count 3 of that I'm sorry, count 4 of that, a criminal threat, that is a severity level 9 person felony. How do you plead, guilty or not guilty?
I plead guilty.
All right. Now I'm going to ask the prosecutor to tell me what he believes the evidence would be if this case went to trial. I want you to listen closely because when he's done, I'm going to ask you if that's what happened. Okay.
All right.
All right. Mr. Campbell.
Yes, Your Honor. If this case went to trial, state's evidence would show that on June 1st, 2019, officers with the Kansas City, Kansas Police Department were flagged down by the victim, Preston Trilk, in the area of 7th and Minnesota Avenue in Kansas City, Kansas, Wyandotte County, where he had a severe laceration to his forehead. He told them that he was robbed by multiple individuals in the area of 2202 North 3rd Street, which is again located in Kansas City, Kansas, Wyandotte County. There he said that multiple individuals, including the defendant, Shaquille Hill, robbed him of a wallet as well as a watch. Specifically, the defendant pointed a gun at him to demand these items, took them without permission, and furthermore, once after taking these items, told him that he had to leave or he is going to shoot him. Again, all in Kansas City, Kansas, Wyandotte County on June 1st, 2019. In just one moment. Correct, Your Honor.
All right. Mr. Hill, you heard what the prosecutor had to say. Is that what happened in this case?
Do you agree the state would be able to present that evidence if this were to go to trial?
I'm sorry.
Do you think the state would be able to present that evidence if this were to go to trial?
I believe they will present it at trial. If we was to go to trial, they will present that evidence, yes.
Okay. Right. At this point, are we making this a no contest plea? And Mr. Campbell, what's your thoughts about that?
Huh?
Your Honor, that is fine with me if we switch it to that.
Mr. Duma, I guess if your client acknowledges that's the state's evidence, but does not admit that that is or the events that led to these convictions, I don't know that there's any choice but to make it a no contest plea. Is that correct?
I'd be, if the state is willing, no objection to that, Judge.
All right. So, Mr. Hill, here's what we're going to do. There's a thing called a plea of no contest. All right. And what that is, unlike in a plea of guilty, where it is required that a person acknowledge that they did the things that they are accused of doing and are therefore guilty, a statement of no contest means I'm not admitting or denying anything, but I'm choosing not to contest it. Now, that makes a difference as to what your position is. Like I said, instead of saying I did what they say I did, it's more like you're saying I am not contesting what they say I did. Either way, if the state provides a sufficient factual basis, which Mr. Campbell has, I'll be making the finding of guilt anyway. Do you understand all of those?
Yeah, I do. I understand.
Okay. So then let's go back here a second. Then as to count one, instead of asking whether you plead guilty or not guilty, I'm going to ask you whether you plead guilty, not guilty, or no contest.
And if you need a second and you'd like to discuss it with me, I'd be happy to do that, Mr. Hill.
Please, can we?
Sure, yeah, no problem. No problem. Let me get those back open again. Oops, I can't do this. Let's see. Delete, yeah. All right, there you go.
And Your Honor, real quick, I might have missed it. I know we had to stop a couple times. If you mentioned whether he's satisfied with Duma as his counsel and stuff like that.
Sure,
I think you went over like the coercion and stuff. I just wanted to make sure.
I will certainly touch upon that.
I just got an email from my travel agent. She says
Yeah.
it's positive. She gave me some links to check out the rest of it, but she said the resort will provide complimentary quarantine lodging if you are not symptomatic, which I assume is not going to be the swim out suite I'll be in while I'm there.
Correct. Yes. I'm sure it would be well far away from everybody. And the free reign, I'm sure that the all-inclusive deal probably doesn't go so well.
Can't keep drinking and
Yeah.
I will be vaccinated. I'm not concerned. And I think my daughter probably has antibodies because both her roommate and her boyfriend had it and she hasn't gotten it.
Yeah. It's you know, those I guess those new strains that are around and have been now reported in Kansas don't really care if you had it before. They are happy to reinfect you.
Ah,
Yeah. All right. Okay, so we were dealing with the no contest issue. Was Mr. Duma able to answer your questions there?
Yes.
All right, he's been doing yeoman's work for you. Are you satisfied with all the advice and counsel that he's given you?
Yes, Your Honor.
Okay, so are we ready to go back to the no contest plea?
Yes, Your Honor.
All right, as to count one, that being aggravated robbery, severity level 3 person felony, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, and as to count 4, the criminal threat, severity level 9 person felony, guilty, not guilty, or no contest?
No contest.
You heard what the prosecutor had to say about what he believes the facts are. Do you understand that if you went to trial, that's what the state believes they could put on for evidence?
Yes.
All right, thank you. Given my review of the official file, the petition to enter plea of guilty, and all of the answers of the defendant today, I do find that he has freely, voluntarily, and intelligently entered into this no contest plea. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for the defendant's plea of no contest, and based on that factual basis, I will find he is in fact guilty of counts 1 and 4. I'm going to order a pre-sentence investigation and continue sentencing pending receipt of that. I had hoped to get a date from I did get a date from my assistant. March 8th, and we're flexible at any time if the lawyers know that they have some time available on March 8th.
I've got most of the afternoon available. And I've got 9 a.m. available.
9 a.m. or 1 p.m., Mr. Campbell?
I'm fine at either time. This will be via Zoom, correct?
Yes.
Okay, I'm
Let's
fine.
let's do 9 a.m.
Okay.
On March 8th. Mr. Hill,
Yes.
as a convicted felon, it's prohibited for you to own or possess a firearm. Certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. All right.
All right.
This is, as we spoke about earlier, this is a registrable offense. So once you're out, you're going to have to register within 3 days of getting out at the county that you will be residing, and then follow their instructions and the law and the registration from there on out. Okay?
All right.
All right. I am going to set the sentencing for March 8th at 9 a.m. Mr. Duma, I would feel more comfortable, given everything that's gone on, if you were to either mail or deliver the petition to the defendant and have him sign it if he's okay with it.
I'll do that.
All right. Anything else for our record?
Yes, Your Honor. I believe you notified him of his duty to register, but I believe specifically, can you make the finding that it was made with a deadly weapon, specifically a firearm?
The factual basis was such that it was alleged and now is proven a person felony committed with a deadly weapon is therefore registrable. All right, thank you.
I think
Anything
that's
else for our record?
No, Your
No.
Honor.
Last one, I think we can all agree on. Go Chiefs. Have a great weekend. We'll see y'all. We're adjourned.
Arriba los jefes,
Hey, los jefes.
los jefes.